within 3 days, PILs are getting listed.
No, it is not being listed,
Yes,
although
yes.
it is
I'll ask
filed
him.
since
I'll ask
Monday.
him. I'll ask him.
Supplementary list for admission, item number 2.
It is not notice were issued. They were supposed to file counter plans.
Counter be filed within 8 weeks, rejoined for the next day. Is there an interim order?
Yes, my lord, there's an interim order.
Interim order to continue. List on 4th April.
Great.
Complied with.
Complied.
Item number 4. Sorry.
Three, my lord, same.
Same order.
Great.
Item number 4.
Over my lord, here I have received the counter day before yesterday. I'll file a resender. 10 days time may be allowed, my lord.
All right. Rejoined to be filed for the next day. 5th April.
Item number
File resender. Counter received from state.
Counsel to the petitioner states that he's filing rejoinder during the course of the day.
In course of day. No.
Ah.
I have time to.
How much time?
My 10 days time.
All right. Rejoined to be filed by the next day.
Interim order to continue.
Interim order to continue. 5th April. Yeah.
Your Lordship will permit me to appear in that matter
Correct.
along with the existing counsels. I'm filing my appearance.
All right.
With the existing counsels.
All right.
I'll be to some case number 1.
Your Lordships will find my arbitration clause at page 142. 33.3, 33.3.1. Last portion.
Right.
Lordships, we've given our arbitration notice, which is at page 295, annexure 19. Lordships. And 304 is
All
our
right.
evidence of delivery.
All
also.
right. Who's for the no yet?
My lord, I am appearing for the opposite party.
Ha.
Copy has not been served, your lordship.
All right. All right. He accepts notice. Free copies be served on him. Reply be filed within 8 weeks, sir.
Lordships, the shorter date. Our bank guarantee is actually, they've tried to encash a bank guarantee. We filed
That
a
you filed
section 9.
9.
We have, your Lordships,
Ah.
but that section 9, they're insisting on hearing. If it's an early arbitration, then that can be
Yes,
converted to section 17 and we can take a
Yes.
relief before the arbitration.
We have not
So they-
received the copy.
If a
We have not
smaller
received the
date will be.
Anyway, copy will be served today, sir.
Lordships.
Reply. Okay. Reply within 6 weeks. Rejoined for the next day.
Their submissions.
13th January. Sorry, 20th January. 20th January. 20th January.
Item number 2. Item number 2, ARBP 77 number 2022.
Pass.
Item number 3. May I please, your lordship. As per the noting, deficit court fees of rupees 400 not paid. Today itself, we have held matter.
All right. Counsel for the petitioner states that the deficit court fee will be paid today.
Okay.
Where is the arbitration clause?
My lord, in clause 13, my lord. Clause 13, page number 20. If your lordship kindly looks at page number 20, dispute resolution, my lord.
All right. Notice returnable. 23rd December.
Oblige, my lord. Item number 4. Item number 4.
Pass over.
Item number 5.
My lordship, I am appearing on behalf of the petitioner, my lordship. My lordship, this is a memo. My lordship, inadvertently, this document was not filed with the petition, my lordship.
All right. This you file it in the registry. I will permit you to file additional documents. Where is the arbitration clause?
My lordship, in number 29, my lordship. Page number 29 of the brief, my lordship. Clause K.
Notice returnable. 6 January.
Grateful, my lordship.
For admission, item 6.
Item 6, my lords, I am appearing today. 4 weeks' time may be granted for filing a reply.
All right. Counsel for the petitioner, opposite party prays and is granted 4 weeks to file reply.
It's authorized it.
Rejoined for the next date. 6 January.
Item number 7.
I know item number 7, we have already received the instruction, we will file the counter within 10 days. Let's make it another 10 days.
All right. Mr. Party states the counter will be filed within 2 weeks. Rejoined for the next date. 6 January.
Like,
Earlier,
the custom name may be reflected.
Madam, that
SS
may
custom
be
name.
some earlier, madam.
But 2 weeks' time is what more?
No, date fixed, my lords had fixed the date January.
All right. 16th December. Okay.
Like,
Supplementary list passed over matter. Item number 2.
Not pressed.
Counsel, the petition states it doesn't press. This is arbitration petition. You should find out what matter you're appearing in, sir.
Item 2, ARBP 77 of 2022.
None appears despite a passover. In the interest of justice, list on 2nd December.
Passed over matter. Item number 4, ARBP 70 of 2022.
Say none appears despite a passover. In the interest of justice, list on. You said defect be removed in the meanwhile. 2nd December. Judgment.
Special list for judgment. Item number 1, MA 307 of 2002.
Send them back. And the appearance will be. So they filed written submission also. The appeal is dismissed. And
Special list fresh admission. Item number 2, CRLMC 2828 of 2016.
Not pressed, ma'am.
dismisses not pressed.
Item number 3,
None appears dismissed.
special list item number 4,
None appears dismissed.
special list item number 5,
None appears dismissed.
special list item number 6,
6, my lord, quashing of the criminal proceeding, my lord. My lord, initially a complaint petition was filed by the opposite party number 2, which has been treated as an FIR, and my lord, and accordingly investigation was carried out. My lord, and final form dated 11/12/2015 was filed, observing that the case was found to be false, my lord. Thereafter, my lord, the opposite party number 2 filed protest petition, wherein the learned JFC and cognizance under section 392 and 34 of the IPC, my lord. My lord, the opposite party being the in-laws of the sister of the petitioner, torture her, due to which an FIR has also been registered, my lord. The complainant are accused in that case, my lord. But to get rid of that, they filed such false, my lord.
It's all right. Permitting the petitioners to raise all pleas urged at the appropriate stage. The petition is disposed of. All right.
Specialist item number 7.
Item number 7, may I please, my lord. My lord, here is the case, my lord. I have challenged the order of cognizance, lordship. Page 8, Annex 1. The magistrate taking cognizance under section 490 of the IPC, that is my challenge, lordship. My grounds of here is the case, my lord, so far as the allegation of 494 is concerned, husband is the informant, wife is the accused, wife is the petitioner before a lordship. My humble submission before a lordship is, so this magistrate could not have taken cognizance under section 494 in the absence of a complaint as enumerated under section 198 of the CRPC. Lordship, 198 of the CRPC says specific bar, lordship, that no court shall take cognizance in absence of a complaint
Have this been served?
if the offences are coming under chapter 20 of the IPC, lordship. Here is the offence 494 is coming under the chapter 20 of the office, lordship. I'm placing the 198, lordship. 190 of 98
Valid
of
service. What is that?
190 of 98 of the CRPC, lordship. That
Yes,
permitted to
it has to
place.
be in a complaint.
There has to be a complaint. Here is the case, wife has filed the
Husband has
filed the
FIR.
yes.
The challenge of the present, you say at the outset, it requires me notice that despite service of notice on the respondent number 2, none appears on his behalf. On 23rd August 2018, the following order was passed by this court. Paragraph. With the respondent 2 not appearing, the chance of referring the parties to conciliation does not arise. Paragraph. It is seen that cognizance was taken against the petitioner on an FIR registered by the respondent 2 husband for the offence under section 494. But there's also 420,
No, I have challenge. My challenge is specific to the 494 only.
494 IPC.
Yes.
Full stop. Counsel, the petitioner has referred to section 195 of the CRPC.
198, lords.
198, is it?
Subsection 1.
1C. 198 bracket C.
Wife is not the complainant, was one only. So far as the proviso is not applicable to the case, but the
I see. All right. 198(1) CRPC, where cognizance cannot be taken of an offence punishable under chapter 20 of the IPC, bracket, which includes section 494 IPC, bracket, open quotation, except upon a complaint made by some person, full stop, unquote. In the present case, it has been averred, without any contradiction, that it was an FIR that was registered by the husband and not a complaint, and therefore cognizance could not have been taken of the offence under section 494 IPC. Full stop. Paragraph. It must be noted here that in terms of the order dated 22nd April 2016 of the SDJM Kendrapada in GR case number 1483 of 2013, cognizance was taken of the offences additionally under section 4920/506/34 IPC. But as far as the petitioner is concerned, she's aggrieved only by that part of the order where cognizance has been taken under section 494 IPC. Paragraph. In view of the clear legal position, it is plain that the learned SDGM could not have, by the aforementioned order, taken cognizance of the offence under section 494 IPC without a written complaint by the respondent number 2 husband, opposite party number 2 husband. Stop. Paragraph. Accordingly, the impugn order dated 24/2/2016 is only to the extent that it takes cognizance of the offense under section 494 IPC against the petitioner. Full stop. To that, the petition is disposed of in the above terms. The interim order stands vacated.
Obliged, my lord.
Specialist item number 8.
A copy of this order be sent to the concerned trial court forthwith.
Obliged.
Item number 8.
None appears dismissed.
Item number 9.
None appears dismissed. If there's an interim order, you say interim order. vacated.
Item number 10.
Permitted to withdraw, my lord, item 10. Item 10, my lord, permitted to withdraw. my lord.
Counsel, the petition seeks leave to withdraw this, dismisses withdrawn.
Item number 11.
None appears dismissed.
Item number 12.
I do not place the matter. I do not place the matter. The petition has died on 28/12/2018.
The petitioner having died, the petition abates and is disposed of as such.
Item number 13.
May I please your lordship? I may be permitted in virtual mode.
Yes.
My lord, in this case, a compromise has been made between opposite party and petitioner, and a miscase to that effect has been filed in 1790/2017. Since the compromise has been made, my humble prayer is for quashing of the case, my lord.
You say miss case number 1790/2017. This is an application praying for quashing of the criminal case 1CC number 4910/2016 pending for the learned SDJ in Bhubaneswar. And the order dated 20th September 2016 under section 156(3) CRPC. Consequent PS case number 263 registered and the corresponding CT case number 4386/2016 registered before the STJ. Full stop. On the basis that a compromise has been reached between the petitioner and respondent number 2, complainant. Full stop. The compromise in the present application is supported by the affidavits of both the petitioner as well as respondent number 2. Full stop. This application was filed way back on 21st July 2017 and has not been contradicted till date. Full stop. In that view of the matter, the said compromise is taken in record. The application is disposed of, and CRLMC 513/2017 is allowed by quashing. Put all those things. Plus.
Obliged, my lord.
Item 14.
None appears dismissed.
Item number 15.
None.
Item number 16.
None appears dismissed.
Specialist item 17.
None appears dismissed.
Item number 18.
None appears dismissed.
Item number 19.
None appears dismissed.
Item number 20.
None appears dismissed. The interim stay is vacated.
Item 21.
Counsel to petitioner seeks and is seeks to withdraw the petition, dismisses withdraw.
Item number 22.
None appears dismissed.
Item number 23.
Permitted to withdraw, my lord.
Dismisses withdraw.
Item number 24.
Stay is vacated. Not pressed. Not pressed, dismissed.
Item number 25.
Fine, my lord. Mr. Bagh is sick, may I play my lord next week? See, he's sick, just.
The counsel, the petitioner is stated to be unwell, list before the roster bench on 3rd January. Item number 26.
My lord, item number 18,
What's it?
on behalf of PK Roy. My lord.
Just pull the mic down, speak louder.
My lord, taken up next week.
Why?
The personal problems.
Not able, you're not audible, madam.
My lord, a personal problem.
All right, counsel, the petitioner is stated to be in some personal difficulty. List on 3rd January before the roster bench. Right. 18. 18. Item number 26. None appears dismissed. Item number 27. None appears dismissed. 26. No, 18. Item 27. No. Item 28.
My lord, quashing of the proceeding on the ground of compromise, your lordship. Compromise, affidavit is there at annexure 3. This is a compoundable offense, your lordship, offense under section 498A, 506 and 323 IPC.
This is a ORIA affidavit. Is that? Mr. Katkia?
No, affidavit is not.
Annexure 3.
That has been executed before the executive magistrate.
Your lordship issue notice, your lordship, to the
All
other
right.
side.
Notice returnable 4th January for the roster bench. Right.
In the stay of further proceeding. I filed-
Nothing is happening, sir.
Sorry. Yes, lordship.
Item 29. None appears dismissed. Item number 30. Check with the interim order then. Item number 30. None appears dismissed. Item number 31. None appears dismissed. Item number 32.
I may be permitted to withdraw with a liberty to raise or relevant point at the
All right.
framing
Permitting
of,
the petitioner to raise all the pleas raised here at the appropriate stage.
at the time of framing charge.
Right. Item number 30. Interim order is vacated. 33. Interim order is vacated. None appears dismissed. Item number 34.
Lordship, the matter is infructuous.
Petitioner is stated to be infructuous, dismissed as such. Item number 35.
Lord, on a FIR filed by the Deputy Director of Mines, Lord, on page 23, that the materials has been stolen from the mines, Lord. The petitioner, who is a raising contractor for Indrani Patnaik Mines, Lord, has been arrested and accused. That Indrani Patnaik case is coming up before Justice R.K. Patnaik on 28th, Lord, specially fixed for that date.
28.
28.
All right. List before the bench of Justice R.K. Patnaik on 28, along with
Messrs. Indrani Patnaik.
CRLMC 1388 of 2017. All right. Now 36. None appears dismissed. Yes. At note 37. Interim order is vacated. Item 37. None appears dismissed. Interim order vacated. Item note 38.
May I please, your lordships? I have seen booking order on the annexure 3, my lord, order dated 3/2/2017, passed by the learned STGM Raigora, taking cognizance of offense under section 307, 506 and 294 of IPC, my lord. So far,
Permit you to raise all, please, sir.
My lord.
Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. All right, the interim order is vacated.
At note 39,
My lord, I raised this point in the time of framing of charge.
Right, same order, interim order is vacated. All right.
Obliged.
at note 40,
None appears, interim order is vacated.
content.
Contempts disposed of.
Item 41,
May please your lordships. This petition in this application challenges the order under annexure 1, wherein the learned JMFC has taken cognizance of the officers on second complaint based on the same self-allegation which were made in the first complaint. And after the first complaint, the learned JMFC directed the police to submit a final form, and in final form, the police stated that the FIR is false and the allegations made out are false. And again, on same self-allegation, these cognizance is taken. The lordship knows well stated, my lords. Second complaint on same self-allegation is not maintainable unless exceptional circumstances arise. Here, these allegations are identical. Your lordship may kindly have a glance at first complaint case at annexure 2, page 9 to 12, and the second complaint is at page annexure 5, page 35 to 39. The lordship may kindly verbatim reproduction of the first complaint case, my lords.
It's been served the opposite party. Neither ED. So nothing has been served, sir, on the opposite party.
Well, sir, notice has not returned, my lords.
And long ago, neither AD nor unserved.
That's my
You permit you to take all pleas, sir. Permitting the petitioner to seek, to raise all the pleas at the appropriate stage. The petition is disposed of. Interim order is vacated. All right.
item number 42,
Obliged.
None is dismissed.
item number 43,
None appears dismissed.
item number 44,
May I please your lordship, on behalf of Mr. K. Rath, my lord, kindly this item number 44 may be withdrawn.
All right, dismisses withdraw. All right.
Obliged.
item number 45,
None appears dismissed.
item number 46,
Permitted to file deficit postal rates. Not at this stage. Sir. Permitting the petitioner to raise all the pleas at the appropriate stage in the trial court. The petition is disposed of. Interim order is vacated.
item 47,
None appears.
item number 48,
None appears dismissed.
item number 49,
Same order.
item number 50,
None appears dismissed.
item 51,
None appears dismissed.
item 52,
Same order.
item number 53,
Same order.
item number 54,
Same order.
item number 55,
Same order.
numbers 56,
None appears dismissed. Interim order is vacated.
item 57,
May I please your lordship? A petition has moved an interim bail application, your lordship, in IA number 2082 on the ground that her widow's mother's illness, your lordship, which is at page, I have given the certificate, your lordship, at page 8.
You have to take instructions. Mr. Katkia. December 2082 of 2022, notice Mr. Katke accepts notice and seeks time for instructions. Your wife is.
No, mother. Widow mother, my lord.
But there must be other children.
No, other children, no, because I'm the only son, your lords.
Acute appendicitis is not a very.
But
serious
she is
thing.
in widow mother, your lords. Nobody has been there to take care, so
I
therefore.
know. Anyway, it takes time for instructions. Next Friday.
Only, my lord, my only getting for 4 weeks time to, because for her treatment and all that.
Use that for a genuine thing, sir.
No.
Next Friday.
Apply.
Second December.
Item 58.
This matter, I would pray, your lordship may kindly grant one chance in the permanent local data. It was ordered, but because of technical reason, my parties could not come. Another chance in the permanent local.
All right. Counsel for the insurance company. You are for the insurance company.
Yes, ma'am.
States
Insurance
that one more chance may be given by before the permanent local list there on 1st December 2022. To be placed before the court on 11 January.
Before local 20th December.
22nd December.
Obliged.
A copy of this order be sent to the in continuous and permanent local. Right.
Item 59.
Appears dismissed.
Item number 60.
Pardon, my lord. Intermod is vacated.
Item 60.
My appearance may be noted, my lord. I am on behalf of the opposite party.
All right. All right. None appears for the petitioner. Dismissed.
Item number 61.
Interim order is vacated.
In 61, I am appearing for the opposite party, my lords. My petition for vacation of stay is also there. The trial has been set at a standstill, my lords, because of the interim orders of this court, my lords, since 2016.
Annexure 8, page 60, the order, my lord, 18/3/2016 is under challenge.
498A.
498A, initially, my lord, cognizance was taken by the magistrate under section 498 and other offences. Thereafter, my lord, the second time, my lord, cognizance was taken under section 376. Your lordship may kindly turn to page 68.
Okay.
And it is sent under section 223 of CRPC to the sessions court. The magistrate has no jurisdiction to take cognizance for the second time, your lordship.
No, different sections, sir. This time it's 376.
Subsequently, my lord,
evidence on record
Yes.
reveals that there is a case of rape.
Yeah. Naturally, you can take cognizance. Yeah.
no, cognizance cannot be taken by law and court below for second time. Once cognizance
for
is
this offense, it's only first time, sir.
no, it is not first time. First time.
376. For 376, there is no earlier cognizance taken.
No, there was no earlier cognizance.
So for
There is-
376 is the first time.
Your lordship may kindly see page 41.
Yes.
Order dated 9/7/2013.
Yes.
Charge sheet number 50 dated 3/7/2013 under section 498A, 323, 497, 294, 506, 406 by 34 IPC and 4 DP Act is received from the IO against the accused persons. I1 such and such persons perused the case record. A prima facie case is well made out against the accused. Hence, the cognizance of offences under section 498A, 323, 497, 294, 506, 406 by 34 IPC and 4 DP Act is taken against them. So serial number 1 to 4 accused are bail by court, serial number 2, 3 accused are bail by police. Subsequently, trial was commenced. Evidence are taken up. And thereafter, my lord, for the second time, my lord, cognizance was taken.
All right. You say the grievance of the petitioner is that
Which is, my lord, against the law and against the settled position
by
of
the
the law.
impugned order dated 18 March 2016, the learned SDJM Attagad has passed an order in CT number 694 of 2012. Sorry, the GMFC Tigriya, the GMFC Tigriya has taken cognizance in CT 694 of 2012 against the petitioners for the offense under section 376 IPC. And that this was impermissible in law since earlier, by an order dated 9 July 2013, the same GMFC Tigriya in the same case had already taken cognizance of certain offenses against the petitioners, including section 498A, 323, 497, 294, 506, and 406/34 IPC and section 4 of the Dowry Prohibition Act 1960. The contention is that once cognizance was taken earlier on 9 July 2013, the JMSC could not again have taken cognizance for the second time by the impugned order. Paragraph. The perusal of the impugned order reveals that this time cognizance was taken inter alia under section 376 IPC on the basis of the evidence that emerged in the course of the trial. Full stop. The impugned order refers to the circumstance under which the JMFC was prima facie of the view that offense under section 376 IPC was also made out against the present petitioner. Paragraph. In that view of the matter, the court is unable to agree that by the impugned order, the JMFC was taking cognizance for the same offense for the second time. So stop. Clearly, this offense is different from the offenses in respect of which cognizance was taken by the earlier order, 9 July 2013. Paragraph. Consequently, the court does not find any merit in the present petition, and it is dismissed as such. It is clarified that this court has not expressed any view on the merits, and it will be open to the petitioner to raise all pleas in accordance with law at the appropriate stage in the trial court.
May I pray one thing, my lords?
The interim order is vacated. Yes, Mr.
And your lordship may expedite the trial, my lords.
Yeah, it will be open to the parties to request the trial court to expedite the trial. Right.
Obliged.
59. Item 59, my lord. I was up with my legs, my lord.
No, tell me.
59.
Tell me.
59.
Yes.
My lord, your lordships have directed the government council to take instruction as to whether sanction has been granted or not.
Mr. Katkia.
First inspection or not? Letter has been issued, yes, sir. Instruction has not come.
All right. Mr. Katkia seeks some more time for instructions. Interim order to continue. List before the roster bench. 9 January.
Item number 62.
Item 62 is the challenge is made to the rejection of the option under section 205 of the CRPC, my lord.
Oh, dispensing appearance. All right.
My lord,
We'll fix a date now.
My lord.
All right. The challenge in the present petition is to an order dated 11 July 2016, passed by the SDJ in Bhubaneswar in 1 CC case number 2045 2015, rejecting the application filed by the managing director.
My lord, by the proprietor and other accused person in individual capacity. Company, my lord, that
by the
company has
proprietor
filed the 305 application.
Proprietor of petition number 1 and petitioners 2 to 5 seeking dispensation with personal appearance of their dispensing of their personal appearance in this said court. Paragraph. Despite notice having been issued way back on 7 November 2016, no reply has been filed Has the complainant been served?
My lord, sir, they have appeared.
All right.
Some advocates are appearing.
Even today, despite service of notice on the respondent complainant, none appears. Paragraph. In the circumstances directed that notwithstanding the impugned order dated 11th July 2016 of the SDJM Bhubaneswar, the petitioners will appear before that court in 1CC number 2045/2015 on 9 January 2023. Further orders may be passed in accordance with law by the said court. No further directions are called for at this stage. The petition is
My
dismissed.
lord, may I pray court in session because due to bifurcation of the jury, it might have been gone to transport to another
Before the
court.
court, yeah, before which the petition is now pending.
Obliged, madam.
All right.
Specialist item 63.
But here I am seeking quashing of the 1CC case under 498, 4 DP Act and other proceedings. I am the major married.
Till then, they may not be arrested, madam.
Okay, till that date, no coercive steps will be taken against the petitioners. All right.
Obliged, madam. Deep you.
Major married brother-in-law and sister-in-law are before your lordship. My lord, here the dispute is 498 or 4 DP Act. We are residing, I am covered by a judgment of the Honorable Apex Court in Preeti Gupta case.
So all that can be shown to the trial court.
My lord, this is a case, but
Because
you cannot quash
opposite
it.
party number 2 returned unserved.
My lord, I had sent notice on 2/11/2016.
I know, but it's all come back unserved.
Your lordship, she is refusing because now they have settled the dispute.
They settled.
They have settled the dispute.
Then
and
that
this
she will not appear in that matter at all then.
No, my lord, unless it is quashed against me, my lord, I am facing.
Problem is if it is settled, you have to file a compromise petition.
Settled between husband and wife. I am the brother-in-law and sister-in-law. I have been added in the one.
No, some document has to be shown to the court that
My
they
lord, your
compromised.
lordship, kindly see this judgment. After that.
Not judgment. Factually, you have to show there's a
Yes,
compromise.
it is squarely covered by my case.
So here you have to factually show there's a compromise.
Then your lordship may post some other day, I'll produce that document.
All right. At the request of Mr. Bose, learned counsel, the petitioner.
Your lordship may keep that
Who
judgment
wants-
on record.
All right. Who wants time to produce a document to show compromise was reached between the husband and wife? List on roster bench on 16 January.
Interim orders may be.
Interim order to cut.
Item 64.
64, I am in VC, my lord.
Ah.
My lord, may please, my lordship. The petitioner is the assistant engineer in charge of a work, my lord, which work was entrusted in tender to one Chakradhar Behera. The FIR has been filed by the brother of the power of attorney holder, stating that some miscreants, but he has named it in the FIR, has tried to kill him and threaten him for taking some money from him. And in that there is a bad allegation that I am also involved in the case, of which you will prove it during the investigation. During the investigation, no, nothing came out, my lord. And page 73 is the cognizance order, my lord. Has your lordship got it?
But Mr. Pal was appearing for respondent number 2. I don't know what happened today. Just list for the roster bench on 17 January. Interim order to continue.
This code by this 63. Before I am not.
Mr. Pal.
My lord, I am there, my lord, but 64. I was engaged. They have taken the brief. I don't have the brief now.
All right, you just say Mr. Pal, who is appearing earlier for respondent 2, states that he does not have the brief now. It's a fresh notice, returnable 24 January. Interim order to continue. Right.
Item 65.
None appears dismissed. Interim order is vacated.
Item number 66.
66, your lordship, to raise all the points at the time of present of charge.
Permitting.
My lord, my appearance will be noted.
All right. The interim order is vacated.
My lord, your lordship may only pass an order that the trial court can expedite the trial.
All right. It will be open to the parties to request the trial court to expedite the trial. All right.
Item 67.
67, my lord, I will take instruction, taken next week, my lord.
For what, sir?
And that is yes, it's challenging of a cognizance, sir.
Take all the pleas at the appropriate stage. It's permitting the petitioner to take all pleas at the appropriate stage. Interim order is vacated.
Item number 68.
Under item number 68, my lord, the petitioner has challenged the order of cognizance on the ground of jurisdiction. The learned JMFC has taken cognizance under section 3 SC/ST Act, besides others offences under IPC, my lords. At that time, the amended act came into force. As per the SSTP Act under section 14, the special court is competent to take cognizance, my lords. And the learned James has no jurisdiction to inquire into the matter and take cognizance, my lord.
But have you served the complainant?
Yes, my lord, complainant already appeared through lawyers.
All right. You say despite service of notice on opposite party number 2 and is having been represented by lawyers earlier, today none appears on his behalf. The challenge in the present petition is to an order dated 1st July 2016 passed by the JMFC Narsinghpur in 1CC number 86 of 2013, taking cognizance inter alia of the offences under sections 447, 294, 323, 379, 506 read with 34 IPC, as well as section 3 of the SC and ST Act. Paragraph. As far as the impugned order has taken cognizance of the offence under section 3 SC/ST Act, it appears to be without jurisdiction, since that can be done only under by the special court under the SC/ST POA Act, section 14.
14, my lord.
Full stop. On that short ground, the impugned order dated 1st July 2016 of the JMFC Narsinghpur in 1CC case number 86 of 2013 is modified by deleting the portion where cognizance is taken against the petitioners for the offence under section 3 of the SC and ST POA Act. Full stop. The interim order shall stand vacated. The petition is disposed of in the above terms.
Item number 69.
I may be pardoned, my lord. My lord, I may be pardoned, my lord. Well,
Yes.
I was misinformed by that file was taken out. That in fact, that file is here, my lord. I'm misinformed by. I'm sorry, my lord.
What's all this?
Can it be taken up next week, my lord?
No, on the same day. We'll just take it up on the same day.
Only that part your lordship may delete that.
All right,
notice
all right.
part your lordship may delete that.
All right.
I'm sorry, my lord.
Item 69.
None appears dismissed. Interim order is vacated.
Item number 70.
Infractors dismissed. Interim order vacated. All right.
Item 71.
Therefore, Mr. Tripathi, no instruction.
No instructions dismissed. Interim order vacated.
Item 72.
72 may PLC. The case of my lordship, the case and counter case between the parties, my lordship, case arising out of matrimonial dispute between the parties, my lordship. That there one cause of action and two FIR has been different FIR has been lodged. That annexure 3 and 4 has annexure 2 and 3 and is lost by the wife and annexure 1 is lost by the husband, my lordship. And in page number 47, that mutual consent mutually that the compromise has been done between the parties, mutually divorce has been agreed by the Law and Family Court, my lordship.
What's the date of that compromise?
That compromise date has been that the Law and Family Court has directed to give permanent alimony of 4 lakh 20 lakh.
No, this is only a petition. Where's the date of the where is the order? There's no order, sir. It's only a petition. So we'll permit you to raise all pleas. So permit the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. The interim order is vacated.
Obliged.
73.
May I please, Your Lordship? The Lordship, I'm seeking quashing of criminal proceeding offence 341, 323, 294, 506, and 34 of IPC. The matter solely arises out of a civil dispute, my lord, that the petitioner's family and opposite families, the grandfather is the same. half of the property was transferred to the petitioner's parents, half property was transferred to the opposite party's parents. Opposite party had filed a plaint regarding right title and interest in 2014 in civil suit number 209 of 2014. Consequently, my lord, it is dismissed also in 2014, and the next remedy is an RFA, but they have filed an FIR in 2016. And it's 2014 the civil suit was filed, and it's still now it's dismissed. And in 2016 they have
this you can point out, sir, to the trial.
Your lordship will kindly one judgment.
Discharge, in your discharge application, you can point out.
Kindly one judgment, my lord, one judgment. One judgment of the Honorable Supreme Court. Your lordship will kindly let me place two paragraphs in paragraph 22 and 23. In 22, by an analysis of the terms and conditions of the agreement between the parties, the dispute between the parties when appears to be purely civil in nature, it is a settled legal proposition that a criminal liability should not be imposed in disputes of civil nature. It is seen if a matter which is essentially of a civil nature, it has been given a clock of criminal offense, the criminal proceedings are not a shortcut of other remedies available in law. Before issuing process of a criminal court has to exercise a great deal of caution. Accused, it is a serious matter. The court has laid certain principles on the basis of which the High Court has to rely. My lord, the civil suit.
Let me ask him.
There is a clear cases made out on the basis of FIR. So kindly see the FIR. There is assault is there, the threatening is there.
No. Is this all after the civil suit or before?
So after civil suit, my lord.
No, civil suit is lordship kindly say after this. Lordship kindly see whether the FIR is made out or not.
No, date, sir. He says there was a civil suit instituted which was dismissed for non-prosecution.
I don't have that.
No, he set it out in the petition.
Yes. Civil suit number 209 of 2014. The
Which
FIR.
which paragraph you said that?
Paragraph 7, my lord. Paragraph 7, my lord, and annexure 4. We had also filed a probate case. That probate case was allowed.
No, but when you said this, it was pending. Now come to para 8.
Well, in the meanwhile, it is dismissed.
Where do you have said that, sir? And where is the dismissal order?
My lord, I will seek for the dismissal order. I will ask the client.
Counsel, the petitioner states that the civil suit filed by the respondent on the same cause of action already stands dismissed for non-prosecution.
Plaintiff had not appeared.
He seeks time to produce. He states that he'll produce a copy of the said order with an advance copy to counsel for the opposite party before the next date. This before the roster bench on 31st January.
The interim order
to continue.
Obliged, my lord.
Item 74.
May it please your lordships. But whenever charge has been framed under the office tribal by the magistrate subsequently, my lord, sent it for trial to the sessions court. That is under challenge before lordship. Lordship may kindly see page 53, order dated 17/12/2013. Accused persons are absent and allowed to be represented under section 317 CRPC for today only. Not only APP as well as defense counsel are present, heard on the petition of charge, perused the case record as well as the police paper, the prima facie case under section 341, 323, 294, 534 IPC. These offences are triable by magistrate are well made out against the accused persons. Hence, particulars of offences under section 341, 323, 294, 506 by 34 IPC are read over and explained to the accused persons, to which he pleads not guilty and claim for trial. Lord APP orally submitted to issue summons to charge sheet witnesses, hence issue summons in 2 suitable dates, put upon such and such for trial. Thereafter, my lord, 26/10/2016.
Whom are you for?
I'm for the informant. My lord, may kindly see page 52. Para 2.
Yes.
Peruse the available materials on record, that is SI statement under 161 CRPC recorded by the IO, so and so, and statement under section 160 CRPC and other connected documents and contents of the case diary along with charge sheet On perusal of the material, I find prima facie case under section 341, 322, 323, 294, 506, 34 IPC is well made out against the above mentioned accused persons.
Persons serial number 128.
128. And
Huh.
prima facie
And prima-
case under section 366, 376.
506 IPC is well made out against the accused number serial number 9 who expired. Number 9 is concerned, your lordships, he expired. Your lordship, it is also reflected in the order sheet. Your lordship will come to my lord page 53. The order dated 7/11/2013. Against serial number 9 accused person, my lord 366 and 376 IPC is taken cognizance. He expired. Accused persons are allowed to be represented on section 317 CRPC for today only. Period the case record. Accused Sachikanta Das is absent and returned without service with report of process server Lakshmindra Sahu that the above named accused has already been expired since 2 years. Subsequently, the Law and Counsel for the accused Sachikanta Das files a memo of accused Sachi Das is dead. Report submitted by process server and Law and Counsel, and the case against Sachikanta Das stands abated and continue for other accused persons. So for the present petitioner, only these offences are taken cognizance and also charge has been framed. Whenever serial Sachikanta Das is concerned, your lordship, that is under section 360 and 376. That order of report.
So you are agreeing only by the
No, cognizance, sending it for trial to the Court of Sessions, because the offences are triable by the magistrate. The offences under which, my lord, the cognizance was taken against the present petitioner.
Now that he's died, the 76 charges are more. The grievance in the present petition is to an order dated 26th October 2016, passed with the JMFC Nimapada in GR case number 381 of 2010, whereby cognizance is taken of the offences under sections 341, 294, 323, 366, 376, 506, and 34 IPC.
376 was not, my lord, taken cognizance. Only 341, 223, 23, 294,
376 was taken, you say he's now died.
Mine.
In GR case number 381 of 2010, corresponding to Go PS case number 78 of 2010. Paragraph. At the outset, it must be mentioned that as far as the offence under 376 IPC is concerned, cognizance is taken only vis-a-vis petition accused number 9, Sachikanta Das, who happens to have expired even before the filing of the present petition. Paragraph. Admittedly, only because offence, the cognizance is taken of the aforementioned offence, that the JMFC by the impugned order committed the case to the Court of Sessions. Full stop. Paragraph. It is stated now that accused number 9 has since expired. In that view of the matter, as far as he is concerned, the criminal case stands abated, since cognizance again of the offence under section 376 IPC was taken only vis-a-vis the said accused. With his having died, the basis for committing the case to the Court of Sessions no longer exists. Paragraph. Accordingly, the order dated 26/10/2016 is hereby set aside. Of the JMFC, Nimapada is hereby set aside. Full stop. The criminal case, that is CT number GR case number 381 of 2010, corresponding Go PS case number 78 of 2010, will now be listed before the JMFC Nimapada, District Puri, on 5th January 2023, for being further proceeded with in accordance with law. The petition is disposed of.
With the lordship's permission, I have wrongly stated item 72, my lordship. Their wife has not received the permanent alimony, my lordship. Item 72, my lordship. The decree of divorce has been mutually has been dissolved inside, my lordship. That permanent alimony has received by the wife, my lordship.
Where is the proof of all that, sir?
All that page number 48, my lordship. That the order has been passed by the Law and Family Court, my lordship. I only privilege that the all.
No, page 48, there's no order plus, sir. That's simply an affidavit.
No, not affidavit or.
No.
Order is not there.
CRLMC 530, no?
Yes. 530.
Page 48 is simply an affidavit. Let the order remains. Sorry.
Order or next 48, page 48, the decree of a divorce be passed in the marriage between
Just
the
showing
parties.
page 48, the hard copy. You can't show your copy, sir. You have to see the copy we have in court.
Miles. That has been wrongly typed as page
I
47.
can't help all this, sir. Sorry. Yes.
47. My lord said that I apologize, my lord. That
It's all right. What
already,
is the order passed? What's the order?
already set aside that.
Yeah.
Passing
You can urge all this at the appropriate stage. Yes.
Item 75.
I may be permitted to raise the point involved at the time of hearing.
Yeah, permitting the petitioner. All right.
My apparent.
Interim order is located. All right.
Further as well.
All right.
Item number 76.
76, maybe, lordship.
Dear lordship, husband and wife, matrimonial dispute lordship, the let flag B is the affidavit is their lordship. And last occasion, both husband and wife are directed to be appear personally. But today is because the husband is a senior branch manager lordship of Punjab National Bank.
Not necessary, sir. Go by the affidavit.
Lordship, that is
If
flag.
both parties agree that the matter has been compromised, both if the petitioner as well as opposite party number 2 agree that the matter between them has been compromised, the affidavit filed by them on 18 July 2017 is on record. It is placed on record, and the criminal case number and the criminal case being CT number 4999 of 2013, pending the court of the learned SDJ Bhubaneswar, as well as the order dated 16 July 2015 of the said court, are hereby quashed.
Lordship,
the petition is disposed.
Grateful. Item 77.
Infructuous dismissed, interim modificated.
Item 70.
78, I am permitted to raise all the point at the time.
All right. Permitting the petitioner to raise all.
Appearance of Mr. Pikerath for opposite party.
All right.
Item 79.
May I please, your lordship? Here, my lord, the petitioner is the victim herself, my lord. She has filed this 482 petition challenging the impugn order under Annexure 3, my lord, rejecting her application under 311 CRPC, my lord, petition under 311 CRPC, my lord. In pursuance to complaint of the present petitioner, my lord, FIR under Annexure 1 under Section 376, 6 of POCSO Act, etc., my lord. Thereafter, my lord, the opposite party number 1 is also appearing, my lord. The opposite party number 1 pressurized, threatened the petitioner, for which she said something else in the court, my lord. Thereafter, she has filed this petition 311 to tell the truth before the court, my lord. That has been rejected, my lord. Petitioner before your lordship is the victim herself, my lord. At any stage, 311.
You are the accused, is it?
My lord.
I am for the accused.
Each for the accused, my lord. I am for the victim, my lord.
So why are you objecting, sir?
One thing I will draw your lordship's attention to, my lord. Your lordship knows the scope of 311, my lord. Well, she says that in earlier deposition, she has deposed falsely and lies. Now she wants to rectify it. Whether that is permissible under 311.
We don't know what she's going to say. So how do you know she's going to rectify it?
She says that, my lord. Her petition is there. And
you are anyway there to cross-examine her, sir.
And that
you are anyway there to cross-examine her.
That scope is with me, my lord, I can dispute. But whether such a petition can be allowed, that is your lordship to, my lord.
Yes, my lord, in view of the judgment of this honorable court, my lord, reported in 2011, 48 OCR 374, my lord.
What is that? Show.
I have not got the Xerox.
Yes, what do you say?
Another aspect, if your lordship will permit me, it's too technical a issue, my lord. But she is being represented by a lawyer. She has filed a petition without endorsement of the lawyer concerned, my lord. That there. So what is the authenticity of this petition, my lord?
She's herself filed it here.
My lord, but not, my lord, signed by her lawyer. So
It's
whether
more
she has
important that
filed-
she signs it, whether lawyer signs or not is not so important. He's the lawyer. He can now take it and sign it. What is that?
Learned friend is not.
If she had not signed it, you
So
can
it's a
understand.
technical issue, my lord.
No. He's very much there. So if you want him to sign, he'll sign it right now.
No, my lord. The petition filed at court below. That petition was filed by the girl and.
But the impute order doesn't say that. The impute order
petition is
doesn't
there.
reject it on that ground.
Petition is there.
The impute order is not rejecting it on that ground.
Petition says that had learned counsel for the victim. So she is being represented by a counsel. But
It's all right, but the court below has not rejected the petition on that
on
ground.
that ground. He has assessed the scope.
There was page 18, page 17.
Yes.
Order dated 25th October 2016.
Ha.
The last part is consequent of petition and supplemental 11 CFPC start rejected will be what of it. Thank you. Page 9.
Sorry. No, that's why he's challenged that order only. The present petition is by a victim who was declared hostile by the trial court in the initial stage after her examination in chief and cross-examination in CT case number 238 of 2013 in the court of the Special Judge Kalahandi Bhavanipatna, which was registered against the respondent Boban accused for the offences under sections 376 bracket 2 bracket 1 bracket B. Oblique 292-A, capital A, oblique 500 oblique 506 IPC, read with section 6 of the POXO Act and section 6 of the Indecent Representation of Women bracket Prohibition Act 1986, as well as section 66 capital E of the Information and Technology Act 2000. Full stop. By the impugned order dated 25th October 2016, the Special Judge Kalahandi Bhavanipatna rejected the application filed by the petitioner under section 311 CRPC, praying that she herself should be allowed to be recalled and examined afresh, further examined in the trial paragraph. After hearing counsel for the petitioner as well as counsel for the accused, the special judge rejected the application on the ground that on the basis of the victim having declared hostile, the accused had already been enlarged on bail, and under section 33(5) of the POCSO Act, the special court was to ensure that, open quotation, the child is not called repeatedly to testify in the court, unquote. The court observed, open quotation, in the absence of any material that the best interest and welfare of the victim is affected, this court does not find any justifiable reason to recall the victim for further examination, full stop, unquote. Counsel, the petitioner has pointed out that in the application, the petitioner had clearly stated that she had been pressurized by the parents of the accused to suppress the truth, promising that to accept her, but subsequently they resiled on that promise. Full stop. As a result, she wanted truth to come out. Paragraph. He also refers to the decision of this court in State of Orissa versus Durjo alias Duryodhana Sanamaji, 2011, 48 OCR 374, in support of his plea. Paragraph. Learned counsel, the accused, on the other hand, resists the above plea on the ground that the victim was fully aware of the facts and voluntarily deposed in the first instance, and permitting her now to be recalled for examination would amount to making good the case of the prosecution, which should not be permissible, which should not be permitted. Stop. Paragraph. Having heard learned counsel, having considered the above submissions, the court is of the view that in the present case, that special judge was not right in the observation that in terms of section 33(5) of the POCSO Act, the victim was being called, open quotation, repeatedly, unquote, to testify in the court, and therefore her application to section 311 CRPC should be rejected. Full stop. This is a case where the child herself is applying under section 311 CRPC to be recalled in order to place the entire facts within her knowledge before the court. Full stop. Therefore, section 33(5) of the POCSO Act was not a bar to such a request. Paragraph. Further, where the victim herself is saying that she was pressurized into suppressing the truth and wants to now speak the truth, it cannot be said that this is not in the single court's best interest and welfare of the victim, unquote. Full stop. Therefore, on this count also, this special judge appears to have erred in law. Paragraph. As far as the apprehension of the accused is concerned, he will in any event have a full opportunity of cross-examining the victim. Full stop. Consequently, that cannot be a reason to decline the application for recall. Full stop. The attempt of the trial court should be to arrive at the truth. And if the victim herself is stating that on accounts of a false promise held to her by the parents of the accused, she had suppressed the truth in the first instance, that cannot be brushed aside lightly by the special judge. That could not have been brushed aside lightly by the special judge. Paragraph. For all the aforementioned reasons, the court finds the impugned order dated 25th October 2016 to be unsustainable in law, and hereby sets aside the application filed by the petitioner under section 311 CRPC will be treated to be allowed. Full stop. She will now appear in the trial court in the aforementioned CT case number 238 of 2013 on 16 January 2023. Full stop. The examination should take place in the Vulnerable Witness Deposition Center. Full stop. It is made clear that the accused who's present here, who's represented by counsel here today, will also remain present in the aforementioned court on the said day. The copy of this order be sent to the concerned court forthwith.
Apply.
Item number 80.
Well, here I'm challenging the order of cognizance, my lord. The arising of a complaint case, my lord. Earlier affair was lodged and subsequently that was found false, my lord. Again, one complaint was filed and the dispute is civil in nature, my lord. The offense is 436 is susceptible offense. I feel that maybe surrender and that may religion bail and trial, first trial, my lord. The 436 is matter because there, my lord, master has no power.
We will permit you to urge all the police, permitting all the police at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated.
When I surrender religion bail, that may be. Because surrender religion bail, my lord, because the 436 is susceptible offense. The master issued summon, my lord. So that may be difficult for petitioners. That is
nothing like that, sir. There's no other
Some lady-
interim order of stay of the proceedings. That's all. All right.
Item 81. Item number 81.
None appears dismissed. The interim order is vacated.
Item number 82.
Here there are 4 cases, my lord. Cognizance under section 162 of the Companies Act. Now, my lord, it is 92 of the Companies Act. My lord. The petitioner before your lordship is not an accused. All the accused persons have already been expired. And my challenge is made that the cognizance is barred by limitation first, because it is a petition for, it should be filed within 6 months of the cause of action, my lord. Your lordship will kindly see the order, the complaint petition at page 12, my lord. Paragraph 5, the cause of action arose on 30/11/2001, whereas the complaint petition was filed on December 2002, my lord. It is first, my lord. Second thing, my lord, the complainants, my lord.
Who's appearing for the registrar of companies? Who's appearing? Mr. A.K. Bose was there earlier.
My lord, he was the central government counsel at that.
Now I don't know who that is. Why don't you serve on Mr. Padi?
Yes, my lord. I will.
A complete set of the papers be served on Mr. P.K. Padi, learned DSGI. List on 6th February before the roster bench. Interim orders to continue.
All 4 cases, my lord.
All 4 cases. Okay.
Item number 83.
None appears. Dismissed.
Item number 84.
None appears. Dismissed. Interim order is vacated.
Item number 85.
At the time of framing of charge, I'll raise all the points.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. Interim order is vacated.
Item number 86.
May I please, your lordship. The matter has been amicably settled. Annex 2, I have filed, my lord. Both are staying together, husband and wife.
All right. Copy of the compromise petition is at Annex 2. This has not been disputed by counsel for the state. Counsel for the
OP2 and 3.
number 2 and 3 are also present and agrees that the matter has been compromised, has been settled. In that view of the matter, FIR dated 13 to 16 FIR must have a number, sir.
Yes, Rambha PS case number 173 of 2016.
FIR PS case number 173 of 2016 in the PS.
Rambha 173 of 2016 corresponding to GR case number.
1 minute, sir. PS Rambha, District Ganjam, corresponding to GR case number 647 of 2016 in the file of the JMFC High Court, and all orders consequent thereto are hereby quashed.
Obliged.
Number 87.
Yeah, please, ma'am. The matter has been compromised. It is for quashing the GR case 222 of 2016. The OP number 3 has filed an affidavit, which is on record.
All right. The affidavit of OP number 3 stating that she and petitioner have married and are staying together, husband and wife, is taken on record. Consequently, GR case number 222 of 2016 arising out of Champua PS case number 90 of 2016 pending the court of the SDGM Champua, and all proceedings consequent thereto are hereby quashed.
Item number 88.
Infractuous dismissed. Interim orders vacated.
Item 89.
My lord, the points raised in this petition may be raised at the time of hearing.
All right. Permitting the petitioner to raise all place at the appropriate stage. Interim orders vacated.
Item number 90.
The petitioner assessed the cognizance order taken by the SDGM Fulbani, your lordship, under section 294. The case of the petitioner is that petitioner is a peon working under municipality, and while he is performing his duty, the complainant raised objection, and there is some alteration, hot alteration. In 1911-15, he lodged a complaint in 7/10/2016. After passing of 1 year, he filed a complaint petition, and the learned SDGM have taken cognizance on the only on section 294, your lordship. 12 annexure 2, your lordship. The petitioner's case is the petitioner is performing his duty. He is not. There is no. In fact, there is an enmity between the, because he sees the neighbors. He raised such objections. Only
permitting the petitioner to raise all pleas at the appropriate stage.
Yes, sir.
The petition is disposed of. Interim orders vacated. All right.
Item 91.
May I please, my lord. My lord, the injured is the claimant appellant here, my lord. The challenge is the appeal, my lord, on two grounds. First of all, my lord, though the present claimant has disclosed the policy of the vehicle, my lord, policy number of the vehicle, but the learned court below has saddled liability on the owner of the vehicle, my lord. And second is for enhancement, my lord. In this case, my lord, the
Why don't you go before the Lok Adalat, sir?
My lord, here liability saddled on the owner.
That Lok Adalat, you couldn't settle it.
My lord, because liability is saddled on the owner of the vehicle, though the vehicle was validly insured, my lord, and the owner, he has also appeared before the court below and submitted. This is, my lord, the certified copy given the policy number stating that the vehicle was validly insured. And my lord,
you are for the insurance company.
For our respond to insurance company.
What's your stand?
Yes, madam.
And they have also not denied specifically that this vehicle was not insured, because we have supplied the policy number in the claim petition itself, my lord.
Well, kindly come to the findings of the tribunal. That is on page number 7.
Page number 7, para 7.2. The tribunal.
With the lordship, may I read this?
Yes.
Yes. But the next question that arises for consideration: who is liable to pay compensation? In the instance case, it is not out of the place to mention that there are no documents is filed and proved on behalf of the petitioner that the offending vehicle was validly insured with OP number 2. OP number means NIC, insurance company, covering the date of accident. More so, on partial of the seizure list dated subjunction Exhibit 4, there is absolutely no mention regarding the particulars of insurance policy of the offending vehicle or any connected documents thereof. And in the absence of such, it cannot be said that the offending vehicle was validly insured with OP number 2 at the time of accident. Therefore, OP number 2 cannot be held liable to pay the compensation amount, as the OP number 1 was the owner of the offending vehicle, my lord. at the time accident, and due to rash and erratic driving of his driver, the accident took place. He is liable to pay the entire amount, my lord.
No, but he's now showing that it's an insured.
My lord, in the claim application itself, I am the third party, my lord. The insurance policy is available with the owner of the vehicle, my lord. And as per the seizure list, I have given the policy number, my lord, company, and make OP2 as a party. And my lord, the OP2, who is the owner, has also appeared before the court below and submitted, my lord, can you see, submitted that the vehicle was validly insured.
No, but he did produce a copy of the policy.
Policy, yes, my lord. But they filed the Xerox copy of the policy. Policy number was also given in the claim application, my lord. Claim application itself, policy number is there.
But there is finding of the law.
But
There is no.
If I get the finding, this policy number, is there a policy issued? You should know. You are the insurance company, the policy number is given. You can confirm whether there is a policy or not. As simple as that, sir. You have all the records with you. And that policy number, if there is no policy, you tell the court that.
Yes, but they have not taken also. They have.
The plea of the petitioner, Kamal, who is the victim of the accident.
Further, my lord, further the enhancement is there, my lord.
Yeah, let him find out, sir.
Yes,
Is that the trial court wrongly relieved the insurance company from any liability, particularly since it was the owner of the vehicle had appeared before the trial court and disclosed the details of the insurance policy, which was valid and covered in question, offending vehicle in question. Full stop. He has placed before the court,
my lord, the injured also
copy of
the injured himself also given the policy number in the claim application itself, my lord. That is first. Thereafter, the owner appeared.
He has placed before the court the written submission of the owner. That is respondent number 1. In which it is stated that vehicle OR 02C 5400 owned by respondent number 1 was insured with National Insurance Company Limited, Shahid Nagar branch, Bhubaneswar, as per policy number 153205/2000/6106310 bracket new bracket valid till 17th December 2001. Full stop. It is stated how the driver at that relevant time was Kuldeep Singh, son of Purushottam Singh, having a valid license. Full stop. Even a copy of the insurance policy and the valid license was enclosed with the said statement placed before the MACT. Paragraph, according to counsel, the petitioner, these details are also there in the claim petition. Paragraph. A direction is issued to the respondent number 2 to confirm whether a valid policy was in fact issued with the above number by checking up with its records. To stop the affidavit not later than 1st February 2023. List before the roster bench on 8th February 2023. Over. One point. What's the order passed in that?
My lord, matter has been disposed of in view of an affidavit filed in the year 2017. As per instruction, I am appearing for the respondent number wife, my lords.
Who's the petitioner?
And she wants to file another affidavit. No, my lordship, so in that view, let's see.
All right, you just simply cancel the earlier order. You say list before the roster bench on 13th February, interim order to continue.
Yes.
All right.
Grateful, lords.
All right. All right. Good afternoon, Jasirat.
Sir, pranam.
No.
Supplementary list for orders, item number 1.
And here the
Odisha Power Transmission Corporation Limited. But to draw the transmission line for traction line to supply electricity to the railway. But this line is constructed, that is already tower inside the Balarpur industry compound. It has to be upgraded, and again other structure has to be done. And my lord, your lordship kindly recollect PIL in which your lordship passed the order. So that is in your lordship kindly see page 8. We had filed a writ petition. My lord, in that writ petition, because why we filed? Because while our people went to do that work, some security guard said, no, that is some order of the Honorable High Court and NCLT, you cannot do anything. So then we had sought for cooperation of the district magistrate. The district magistrate is also competent to give all cooperation under section 16 of the Telegraph Act. They also said that we can't do anything unless you get any clarification order from the court. So that is why, my lord, we had this. In that writ petition, my lord,
we had asked NCLT to.
I may draw your lordship's attention to the order, page 33.
Yes.
My lord, here, sorry, 32, your lordship kindly see. In that order, my lord, para 11. My lord, indeed, in the order dated 17 January 2022, the NCLT, yes, 20, the NCLT has issued a series of directions while admitting the petition. The operative portion of the said order is as under. The lordship kindly come to page 33, that is Roman 1B. That is only the constant your lordship, if please may clarify. Transferring, encumbering, and alienating or disposing of by the corporate director any of its assets or any legal right or beneficial interest therein. So your lordship reiterated the same thing while disposing of the written page 35. Page 35, paragraph 16. The court considered it appropriate, keeping in view all the above submission and circumstance, to issue the following direction. The status quo order passed by the court 17 August 22 will continue during pendency of the proceeding before NCLT, subject to any further direction that may be passed by the NCLT in the IBC pending before it. The opposite party 5 and 7 will ensure that no request for a mutation of any land of opposite party 8 is entertained during pendency of the proceedings. But here, what we are doing, there is no question of encumbering any land or transferring any land, and it is a statutory right. And this writ petition we filed, lordship kindly see our prayer. Well, this is in page 20 in the writ petition, that is annexed that your lordship will find starts from page 8. Lordship kindly see. It is that appropriate that this honorable court may graciously please to issue rulings in the nature of writ of mandamus under any other appropriate writ and writs, direction, and orders calling upon the opposite parties to show cause as to why the OP number 1 shall not be commanded to immediately take all effective measures in association and cooperation with the opposite party 226 on the request made on behalf of petitioners as per letters head annexure 4, 5, 7, 8 to solve the problem by preventing the resistance and obstruction in accessing the right of way for construction of 132 kV traction line.
This is a new line you're laying or existing line you're.
Existing line is there, we'll upgrade it. So that is why, Mala, there is no question of transferring or doing anything.
The application there.
Pardon?
And for petitioner to just received the copy.
Some this, I am extremely sorry, your lordship may excuse me. Annexure B by 12, that order passed in the writ petition, in that writ petition, that lord by mistake has not been enclosed. So I am giving that. My lord, Honorable Justice Mahapatra, single judge, expressed the inability that the paragraph 7 and then 8, 9 is relevant.
Why are you not moving the NCLT?
Pardon, my lord?
Why are you not moving the NCLT?
But here, my lord, it is a matter that under the Electricity Act, we have a right of way. We are not going to transfer the land.
No, because we ourselves did not pass orders because it was pending in the NCLT.
Right, but your lordship at the same time can clarify the position while reiterating the same order. There will be no encumbrance, no transfer. And we are not going to, there is no effect of transfer or encumbrance or anything else.
The learned single judge has rejected your prayer.
In fact, it is not rejected. He has given the liberty to, because of your lordship division bench order, that is why
he has given liberty to go to the NCLT.
My lord, not exactly to NCLT, but in fact he has.
No, by the NCLT. Just see the end of paragraph, internal page 10. I don't know if Justice Rautre has a copy of the order.
Yes, I have given that through my junior.
No, I have not. I have not given. Mr. Mahanti, but your prayer is for clarification.
Yes.
You want to install a new new lines.
Yes. New also upgrading.
He wants to upgrade.
Page
No, but we ourselves declined to pass orders because NCLT was serious of the matter.
Page 10 it has also proposing to erect tower, not erect tower and
that scheme I am drawing the lordship's attention that
10 of the improvement.
What prevents you from going to the NCLT is the question.
Only it will be delaying process.
No.
Yes, we will go to provide for the entire public.
The land, see, the land belongs to the paper mill, correct?
That is right.
The paper mill is before NCLT. Anything you want to do on the land, we ourselves said it will abide by the orders of the NCLT. So the best thing is that. The best thing is that we'll say all this and we'll help you go to the NCLT.
Only a conversion.
No, but cannot be helped, sir. Because NCLT sees to the matter, no other court is supposed to pass any order. That's how we ourselves only reiterated what
all the way to move Bombay.
No, there's no all the way. Now it's one flight.
That is all right, my lord. But only thing, lordship, kindly see, strictly going through that order.
Right.
Does it come within
that? So we'll permit you to go to the NCLTs. We'll note both these facts.
Yeah.
You see.
And only your lordship kindly note down that scheme of the work is annexed to page 23.
All right.
Page 23.
All right. The Orissa Power Transmission Corporation Limited, TCL, has filed this application seeking clarification of an order passed by this court in the present writ petition on 18th February 2021. Paragraph. The grievance of OPTCL is that it is seeking to upgrade the existing 132 kV electricity transmission line, which is passing through the land belonging to Messrs. Ballarpur Industries Limited, correct?
Yes.
Bracket, opposite party number 8 in the writ petition, bracket, which is before the National Company Law Tribunal, bracket NCLT. Bracket Mumbai bench, at the instance of one of the creditors of the said company. Full stop. In the said proceedings, an interim resolution professional has been appointed and an order has been passed by the NCLT on 17 January 2020, imposing a moratorium. Paragraph. The clarification sought by OPCTL in the present application is that the said order passed with this court on 18 February 2021 in the present writ petition would not create any impediment in OPTCL installing the transmission line. Paragraph. It must be noted here that OPTL had filed a separate writ petition civil 11002 of 2022 in this court for a direction to the collector and district magistrate Cuttack to grant it permission in accessing the right of way for construction of the very same 132 kV traction line bracket 2 phase from the existing grid substation in Chaudhar to the proposed RTTS Charbatia for power supply connectivity. Full stop. That writ petition was disposed of by the learned single judge by an order dated 2nd August 2022, noting facts and observing that this court bracket, i.e. the division bench bracket, had in the present petition permitted all parties to make appropriate submissions before the NCLT. Stop. Accordingly, the said writ petition was disposed of
Well, that is wrongly said TPC or Delhi. Mistake.
that the petitioner, open quotation, so advised may work out its remedy in the competent court of law, unquote. Mr. P.K. Manthi, learned senior counsel appearing for the applicant, urges that the clarification should be issued by this court itself without the OPT seal having to go before the NCLT, as that would be, in his words, single quotes, cumbersome, unquote, full stop. Paragraph. With the land belonging to the company which is before the NCLT, and with there being a moratorium under the Insolvency and Bankruptcy Code in terms of the orders of the NCLT, it would not be appropriate for this court to pass any orders in relation to the prayer made by the present applicant. In fact, that was the tenor of the order passed with this court on 18/2/2021. Acknowledging the moratorium as a result of the orders of the NCLT and permitting parties to advance submissions before the NCLT. Paragraph. In that view of the matter, while declining to grant the prayer in the present application, the court permits the applicant OPTCL to approach the NCLT for appropriate orders in relation to the relief prayed for. The application is disposed of.
Obliged.
Item.
Same.
All right.
Do we have not filed any petition?
Both you can put together.
Item number 3.
Actually, this is an application for restoration because dismissed for.
What's the main matter about?
The main matter is it's challenging the illegal retrenchment, your lordship, of the petitioners. They are the workmen who were retrenched due to a faulty station list. Juniors to them are still continuing and they had not even received the compensation.
All right, for the reasons stated therein, the application is allowed. The order dated
The writ petition.
23rd July 2021 is recalled, and writ petition civil 31780 of 2011 is restored to file of the learned of the division roster bench, where it will now be listed for hearing on 5th January 2023. The interim order, which was existing, shall also be restored, stand
Okay.
restored.
Obliged, deeply obliged.
And then in the separate writ petition, you say, by virtue of the order passed today in CMAPL so and so, the present writ petition has been restored to file. List on
5th January. 5th January.
5th January, interim order to continue.
Deeply obliged.
Item number 4.
Please, my lords. Application for bail has been filed by appellant my lords, who has been in custody since 27/6/2004
Not now in custody.
as an under.
Now he's not in custody.
Parole.
I am in custody of the court, my lord.
I know, but you are still on parole.
I am still on parole. The parole will on first, my lords.
And then special furlough.
1st of December.
Yes,
Any
any day.
First.
Parole will expire on the 1st of December. I have been directed to surrender.
No, that's good. That's good. That the Odisha COVID-19 regulation has been repealed in the meantime.
Right.
So you should surrender because basing on that, he's there on parole. Special parole. I know.
I am on parole by virtue of an order of the high-powered committee. my lords,
Correct.
relating to decongestion of prisons.
Jails.
The apex.
Correct.
And the high-power committee has stated that I am to surrender on the 1st.
I see.
So I'll surrender on the 1st, my lords.
Can we list it soon after that?
My lords, my
That may be
submission-
better.
My submission, my lords, is that your lordships have considered applications for bail, even in respect of people who are on parole or furlough. I am not on parole, I am on furlough. And the condition precedent is granting me furlough is that it will not be counted towards the period of my.
Custody.
Yes.
Correct.
So my respective submission, my lords, is that when I am custody, your lordship has refused bail and thereafter soon thereafter I was granted parole. And I am continuing on parole without any allegations, my lords. Taking me back into custody, my lords, what useful purpose does it?
No, not in a case like this, because it's a highly contested thing. It's better that your conduct is even more firmly established, your good conduct, by your surrendering.
As of now, there is no allegations, my lords. What
I know.
May submit matters insofar sub item number matters 649 of 2019. I was in parole, but I surrendered. I am in custody now.
All right. You just say criminal appeal 503 and IA number 230 of 2022. Mr. Panda, learned counsel appearing for the applicant appellant, informs the court that the period of furlough will come to an end on 1st December 2022, on which date, in terms of the orders passed by the high power committee, the applicant has to surrender. Paragraph, the court proposes to take up application after the applicant has surrendered. Full stop. List on 9th December.
Lords, why not 2nd December? If I am surrendering on the 1st, why not the 2nd of December?
But the 9th December, my lord, the one of the council, my lord, his brother's marriage there.
No. So then 2nd December.
Second December, my lord. 2nd December.
2nd
December, my lord, the marriage of the.
9th has. Actually, 9th I am at Delhi, the 16th.
In between 2nd and 9th?
16.
In between 2nd and 9th? Because
No,
I am
but,
in custody.
Your lordship
No,
may
I know, we'll
dismiss
have
the
to
application.
constitute the bench. That's fine.
Your lordship may dismiss the application.
Dismissed earlier.
Well, some council's brother is getting married. There is a battery of council standing here, my lords.
Let
And
it be
your
on
lordship
second.
is going to adjourn.
Let it be on 2nd.
Is this a reason, my lords?
Will be there, my lord, the decision on 2nd years.
And elections are held in the evening as per.
No. They are.
Let
Let it be on 2nd. Mr. Ragada, let's be. All right, 2nd. All right.
In the meanwhile, my learned friend take instruction. So far, sub item number 4. I have already surrendered. I'm in custody, my lords.
All right. Sub item 4 is 649. Yeah, in criminal appeal 649, you put down 1463.
My lords.
of 2019. List on 2nd December. All right. Right. Pranam, sir. Pranam. Namaskar.
For orders item number 1. In the first criminal appeal, that is Lordship CRLA 848 of 2019, my lords, I'm filing wakalat on behalf of the appellant number 1, that is Trilochan Behra alias Chilla. And there is a prisoner petition to that respect as per my instruction, my lords. It has been, prisoner petition has been received for engagement of Shri Akhay Charan Kanungo.
Now that prayer is infructuous.
Pardon, lords?
No. The application, which application are you mentioning?
Lords, CRLA 848 of 2019.
That's the appeal itself.
My lords. In that, in the appeal, there are 3 appellants that have preferred the said appeal.
Right.
For the appellant number 1, we have instructions to appear, and to that respect, I'm filing the wakalat today in the court, my lords.
Okay.
I'll file an IA for bail.
You are hereafter going to file IA for bail?
My lords.
Otherwise, it is for your bail, is it?
More, my 831 2019, my lord. Already served 10 years, my lord. And he was undergone, my lord, the bypass surgery, my lord. And taken to health condition, my lord, I filed the IA. On 13th, my lord, on 14th, my lord, pass an order, directly state council take instruction whether any criminal antecedent. No criminal. That's we consider that part, my lord. My lord, because my lord, the 10 years, more than 10 years, day before yesterday, he also, the jail authority taken him to the SC medical college. Health condition, my lord, since day by day.
In criminal appeal 848, you say Mr. So-and-so files his wakalatnama on behalf of appellant number 1 in the present appeal. It's taken on record. Then 831 of 2019, IA number 1225 of 2021.
Your lordship.
This is an application for bail by the appellant, inter alia stating that he has served more than 10 years in custody and is also suffering from heart ailments. Full stop. On the previous occasion, that is, which was the date?
14/10/2022.
14th.
14th October, sir.
On 14th October 2022, Mr. Katkia, learned AG, had sought time for instructions on the criminal antecedents of the applicant. Today, he has produced the written instructions stating that on perusal of the available records, nothing adverse criminally or politically is available against any of the appellants in this batch of appeals, which includes the present appellant as well. Paragraph. In view of the Supreme Court in Singada Singh, and considering that the present appeal is unlikely to be taken up for final hearing in its usual turn, the court directs enlargement of the present appellant Ashok Raut on bail, subject to the satisfaction of the trial court during the pendency of the present appeal.
Your lordship, one thing more, my lord. Your lordship may kindly peruse the order dated 14/1/2020. I am for the informant. Your lordship go to that order.
14/1/2020.
2020.
Criminal appeal 831.
Yes, my lord. There was a direction for preparing paper book and for hearing.
Paper books be, yeah, that's right.
On that day, this case was admitted on.
Paper books should not already be prepared within 4 weeks and supplied to counsel for the parties. List thereafter in the main appeal report.
Lordship, fix the matter to a date, lords, as because it's a
No,
special
whenever you
bench.
file the application, it comes. Right.
Right.
Right. Namaskar.
Supplementary list for orders item number 1.
My lord, this IA has been filed to implementation of the order passed by this honorable court in WPC number 8828 of 2007.
Say
disposed of-
implementation, you have to file contempt, not IA, sir.
My lord.
Counsel, the applicant seeks leave to withdraw the present application with liberty to file appropriate application in accordance with law. Was withdrawn with liberties made for. Yes.
Much obliged, my lord. Item number 2.
May I please your book, sir? Lord, this is the matter for restoration. And
What's the main matter about?
Main matter is for adjust the system of liquor system of the state, Miller. Due to the vast implementation of liquor shops and all these things, the social crimes are getting increasing, and that's why that is the main purpose, like filed by the good numbers of social workers and women condition.
See, the circumstances have changed. Your writ petition was filed in 2012. Whether those circumstances continue or not, we don't know. We'll give you liberty to file a fresh petition if the cause of action survives.
Lord, it is a PIL, they are not paying. It is my.
I know, but still facts and circumstances change. That's why.
Maybe Miller liquors are also, they are getting vastly opening shops here and there. Only may kindly restore the matter, and I will place your.
No, even earlier. See, this was not dismissed for non-prosecution. Just see this. The order passed on 29/6/22. This was not for non-prosecution. Just see the order dated 29/6/22.
My lord, actually my case.
My
lord, my two serial my case number. No, R.K. Patnaik, sir. My lord, restoration of order dated 29/6/22, my lord.
Where is that? It's not dismissed for non-prosecution.
My lord, in this case, my lord, I have no knowledge that honorable court admit the miscase number 6915/2013 and permission of the court, learned counsel already did the party, my lord. So that, my lord, my case is fit case, kindly dispose in merit, my lord. My lord.
No. This is not for recall or restoration.
My lord, kindly, my lord, in this day, honorable court dismiss my case only for I have not
taken steps. Correct.
Yes, file a cost title, my lord.
Right.
Fresh cost title, but due to permission of the court, council, this council already died, my lord. 2015. Arguing died. I have the second, after the died of the second arguing council, I have filed a Baklatnama. I have no knowledge that.
No, you are supposed to inspect the files.
My lord.
All that is very basic. If somebody is giving you a Vakalatnama in a pending matter,
yes,
the least you should do is inspect the file. Actually, you should ask for a paper book. Suppose, assuming that you only got Vakalat and no other papers, you should inspect the court file on the strength of the Vakalat.
When I have getting.
He can't be teaching you what to do, sir, as a lawyer. These are things you should know.
Sir, kindly had any merit.
This is not for recall or
had any merit, my lord, because.
No, sorry, sir. Sorry. There is no merit to the present application. It is dismissed as such. Sorry, sir. Yes.
Item number 3.
Item number 3, my lord, kindly recall the order dated manner, restoration manner. Order dated.
What's the delay?
List has been misplaced, my lord.
No. These are all not excuses, sir. Sorry.
No, similar matter has been fixed, my lord, on 30th November, my lord. On a batch of cases.
In those cases that you get, so you don't have to worry. It will get decided in those cases.
No.
You don't have to have a separate petition.
The matter was on fresh admission, my lord. I will misplace the list. That's why I filed the restoration. The notice has not been issued on that.
What's the delay in filing? No delay. All right. For the reasons stated therein, the order dated, the application is allowed, the order dated 31st March 2022 is recalled. And in the writ petition, you say the writ petition is restored by virtue of an order passed in CMAPL. You say list before the roster bench on
30th
November. All right.
Item number 4.
May I please, your lordship? The main matter is with regard to an order of resumption of lease without notice to the lessee. And it was dismissed for non-prosecution because the conducting lawyer was dead by the date the matter was listed.
All right. For the reasons stated, the application is allowed. The order dated
4722.
4722 is recalled. Order is not there. Scanned and placed. Petition civil is restored to the file of the roster bench. Then in the separate order, you say list before the roster bench on 7th February.
Public.
All right.
Okay, ma'am.
Right.
Namaste.
Namaste, sir. Namaste, sir. Restoration.
Stress admission item number 1.
I am dismissed for default on 18/11/2021. I filed this application on 28/2. Counter has been already filed. Your Lordship may give me one chance more.
All right, for the reasons stated therein, the application is allowed. The order is recalled and this writ petition is restored to file. In the writ petition, you say, let's move for the roster bench on 14th February. Interim order to continue. Right.
Item number 2.
May I please your good sir.
Ah,
Lord, this is the matter
Ah.
for restoration.
right.
And this was when the counsel for the petitioner is out of station, and unfortunately on the first call, it has been dismissed on 13th.
So this implementation of Orissa Prohibition Act,
Yes,
it was there in another petition. We have not entered it. We said this is a
Milord,
policy of the government.
Kindly restore the matter. I will satisfy your good self in all aspects. Any question at that time? This matter may kindly restore.
For the reasons stated therein, the application is allowed. And the order dated 14 March 2022 is recalled. This restored to file list before the roster bench.
On 14th of December, my Miller date may kindly fix on 14th of December. It is an old matter of 2014.
No, roster bench. So we'll have it on the new year. You'll be all energized on 18th January 2023. All right.
Item number 3.
This man. The petitioner is in custody since December 14, my lords. He has prayed for interim bail to arrange for finances for his father's recuperation, my lords. His father has suffered a neural operation and is now recuperating at Bangalore with the petitioners.
All right. You just say notice, he accepts notice and seeks time for instructions. You have it on second? Second. Over. Oh, right.